One night in 1985, attorney Nathan Lewin was awakened by a telephone call.
And I picked up the phone, and it was Rabbi Krinsky, whom I had met in connection with some of these other matters before, and he was on the phone. And he said to me, he's calling me on an emergency basis because there is a library that houses some very valuable Sפרים and manuscripts, and there were volumes from it that were missing, and that had been discovered that were missing. It wasn't known who it was who was taking them, and that they had installed, I was not asked about the installation of that, but that they had installed a secret video surveillance camera, and that they found the person who was taking it on the video surveillance camera. So he authorized me to prepare the papers as quickly as possible, to go to federal court to get a restraining order. I said to the judge, we're here because the defendant is now actively selling these books, and if the judge issues an order that puts the books in escrow and prevents him from selling it, then we're ready to have the rest of the case go to a rabbinic court. We have to select the judges, but nonetheless ready to have it go to a rabbinic court. And Mr. Hellerstein, who's now himself a district judge, responded, "Oh no, Your Honor, the case is now in court, and we want the court to make a decision on who owns the whole library. The whole library is now at issue. We claim that it all belongs to the family and not to the community. We had said it belonged to Agodat Chasidei Chabad." The Rebbe made it clear it was the movement's property, and the desires of his father-in-law, of the previous Rebbe, that this be preserved for the community and not be viewed as simply personal property that anybody can do what they like with. He thought that the key document that this case really should depend on was a letter that the previous Rebbe had written after he got to the United States and was trying to get the books to be brought back from Europe, found and brought back from Europe to the United States, a letter that he had written to Professor Marks, who was the librarian of the Jewish Theological Seminary Library in New York. And this letter said that this library was a treasure of the Jewish people and belonged to Agudas Chasidei Chabad of the United States. The Rebbe said to us, look, the key document is this one which he wrote to Professor Marks. And that turned out to be 100% accurate. I mean, ultimately the decision of the judge, when it was rendered after the full trial, the judge said, relied on that letter as proof of the fact that the previous Rebbe had, he said, held these books in trust. American system of a notion of holding things in trust for somebody else, that he had held it in trust for the community of Chabad. As one of the people whom they deposed, they served a notice of deposition on the Rebbitzin. Now, since the Rebbitzin was the daughter of the person who had collected these books, it was very difficult to maintain that they could not take her deposition. They had a right really to take her deposition. Out of respect for her, it was not done in a lawyer's office, but it was done at their apartment, at the Rebbe and Rebbitzin's apartment on President Street. The most dramatic moment in the depositions, and maybe the most dramatic moment in the whole proceeding, when they made the mistake of asking the Rebbitzin about, you know, didn't your father own things? What did he have personally? What was his personal possessions? Did he have, wasn't this or that or the other thing? You know, his library and his books, weren't they his personal property? And she said no. And they were surprised, and they said, you know, well, what do you mean no? The Rebbe, didn't the Rebbe have personal property? And she responded by saying, no, my father, the Rebbe, was the property of Chabad. He belonged to Chabad, and he had nothing that he had himself personally. He was owned by Chabad.